Okay, today's date is October 16th, 2020. My name is Shayna Horton. I'm the rules attorney for the TABC, and we are here today to speak with stakeholders on a Zoom meeting regarding three different rule proposals. The first is a reorganization of subchapters A and B of Chapter 33. It's non-substantive and just moving things around to get them the way we want them. The second is a brand new rule, 35.8, which is something that we were supposed to have adopted probably a while ago, but it's just come to our attention that we were required by statute to adopt rules for shared winery facilities under 1605 of the code. So that's that rule. And then the third item is 45.103. And the reason for that is that, as you all know, as a state agency, we're supposed to go through all of our rules at least once every 4 years. And now that, the vast majority of our sunset related rules are through, we are starting to cycle through all of the other rules. We're starting with chapters 41 and 45. So if there are things in chapters 41 and 45 that you have concerns about, please do reach out to me as we are going through those chapters now. We're only going to talk about these three items. I know that there are a lot of rule packages that have been proposed and are on the agenda for Monday. So people keep getting confused around here. So I just want to make that clear that today is stakeholder on three rules that have not yet been proposed and are still very much in the draft stage. And Monday is the public hearing on the rules that were proposed at the last commission meeting. Let's see. I want to thank you all for your early engagement. As always, it's really helpful to me to understand what the issues are before proposal because it's so much easier to make changes and make the rule workable for all of us at this stage rather than after it's been published. So I'm really glad that you're all here, and I'm looking forward to all of your comments, and I always want as many comments as we can get. And I understand there are a lot of folks today that do have some concerns and issues they want to discuss. That's exactly what this meeting is for. And I thank you for being here to do that. When you do speak, you will have to raise your hand. I will unmute. Actually, I believe you can unmute yourself. But I will call on you. And then please say your name and who you represent before you begin your comments. And please do that each time, just for the sake of the recording. It's just, helpful to make sure that we know whose voice is what. And with that, let me see if there's anyone waiting to get in. No, we have 65 participants, which is wonderful. Let's go ahead and start on item number 1 on your agenda. I am going to, is anyone having any trouble hearing or seeing anything? Can put that into the chat. Okay. I'm opening documents. Again, I'm doing this from home and by myself, so there are some challenges related to that. And there will be some slight lags in the conversation because of that. Okay. So we are rearranging parts of most of chapter 33, as you're aware by now. The rearrangement we're doing here is we've done a crosswalk for it to hopefully help you find where things are going when this switch does happen. The one thing that this does not do, it does not impact the 2-year permit fees at all. So again, these are intended to be non-substantive and just rearrangement. Didn't expect to have a whole lot of controversy about these. So I will open the floor to admit some folks here. I will open the floor to you all if you have questions or concerns about this rearrangement only? So raise your hand if you would like to speak. Okay, I'll share my screen.
Shauna?
Yes.
Marcus Schwartz, Bracken Schwartz, PLC. And this relates to 3322. Are we talking about the new rule or the new language now, or are we just talking about crosswalk? Sorry.
Oh, we can talk about the new language now. We can talk about anything on item 1.
Gotcha. Had a question 3322, see the administrative fees for supplemental applications. Are those going to be broken down? I guess one comment I have, for instance, if there's a change in ownership, and the ownership is some third-party landlord, for instance, that's nothing the permittee's done. Are they going to be charged for having to do something that's completely out of their control, so to speak?
We haven't actually talked about what exactly will be. This is just to leave it open to us. So we haven't had the conversation about what the exact fees might be or things that we might charge for. The reason for doing this is just that there's a lot of work involved with a change of address and a change of ownership of the business. So when of the permit holding business. So when those happen, we want to have the ability to recoup some of the money spent on employee resources. But I don't really have details as to exactly, which transactions that would be. And again, that these would be fees that are like administrative fee nature, not like a 2-year permit fee at all.
Understood. I guess it gets weird because so say you do have a change of ownership, but literally one owner that owns 99% and another owner owns 1%, and the 99 just buys the 100 or the 1% out, then you're really just deleting one person, and that obviously isn't the same as when you got a whole bunch of different people on, and so I didn't know if those would all be treated the same to where or an officer resigns, right? They're just off and no new officer comes on. Those are different than, and obviously a lot less work than if it's something else. So
right.
I would put that to your consideration, so to speak.
Okay, thank you. Yeah, and I think, the idea here, we're supposed to charge fees essentially to cover our expenses and not a lot more than that. So the idea here is just for the things that do take a lot of time, that those might have a dollar amount attached just to make those changes. The things that require new investigations, of a new location or something like that, because those can be almost tantamount to a new application as far as the workload. But if it's something minor like that doesn't have that kind of work, then I think that's not what we're looking at.
Understood. Appreciate it. Thank you.
Thank you.
Good morning. This is Amy Harrison. Can you hear me?
Yes.
Amy Harrison, representing myself, Amy Harrison Consulting. Again, about 33.22, to follow up on Marcus's great question, is because of the fact that the rule says or other administrative changes, would it be possible to outline or list what administrative changes the commission's going to feel are worthy of charging fees for? A change of mail is quite simple. There are several changes that are required under the applications that have been created. And I just think that before people should be voting on a rule that allows for fees to be charged, they might want to know what are those administrative changes that the commission feels are worthy of their money. So that would just be my comment.
Okay. Thank you, Amy.
Thank you.
I'm also having a little bit of trouble just because my two-screen system is not working today, so I'm having to flip back and forth. Does anyone else have any comments about item number 1, whether substantive? I mean, I guess that when I said it was non-substantive, you're right. There is one substantive change, and that's the one that people have been talking about. But the rest is rearrangement. Okay. There are no other comments or questions about this one. Then we will go ahead and move on to item number 2. I understand that there are a number of folks that are here to talk about item number 2, which is draft rule 35.8. Again, as I stated earlier in the meeting, it was brought to our attention that Alcoholic Beverage Code 1605 requires rulemaking that would allow G winery permit holders to work together and in shared facilities. But we need to, some folks are wanting to do that now, so we need to adopt a rule so that we can authorize that and then also regulate it, audit it, make sure that people are keeping things separate and all of that. So what we've done is put together a rule that is really quite basic. We're expecting to get a lot of input from you all about it. So I'm glad y'all are here today to talk about it, to make sure that it does what you need it to do and nothing more. So I'm going to go ahead and start. Let's see. Lance Lively, I think, wanted to speak. If you want to go ahead, Mr. Lively.
Can you hear me?
Yes.
Good morning. My name is Lance Lively. I'm the Executive Director of the Texas Package Stores Association here in Austin, Texas. In reading this proposed draft rule, we have some concerns regarding the implications of overreach. Obviously, this law was passed back in 2005. So here we are 15 years later. A lot has changed in the last 15 years. We would want to hopefully encourage the agency to allow us to address this issue, not just at the legislature, but out at the agency as well, with some time to digest all of this. I think there are serious legal implications surrounding this that I want to try to avoid, and I know the agency would like to try to avoid that as well. I'm not saying we're opposed to the concept, but we certainly do want to inject our thoughts and ideas regarding storage, shipment, and the potential impact that this could have on the Texas winery industry. Obviously, our members sell a lot of Texas wine, and there are a lot of great products out there that we move, and we want to support them to the fullest extent possible. So we would have some concerns regarding this in terms of what it looks like and stands for, and look forward to the opportunity to continue the dialogue on this draft rule. Thank you.
Thank you. Any raised hands here?
Shanna, this is Amy Harrison. Can you hear me?
Yes. Go ahead.
I apologize, but I'm slow on the take, as everybody on the call knows. But would you mind walking through this rule and sort of the thoughts of the commission and why, as Lance mentioned, the provisions for this passed moons ago, and I believe people have been engaging in these types of activities. So if you can just give us a background of how, when, and where, and why, that would be incredible for those of us that have been really consumed with food and beverage certificates lately. Thank you.
I am going to ask for Thomas Graham to help me out here, because there's a lot of background that I wasn't really a part of. I do know that it just came to our attention that people have been operating and want to operate together, and we just haven't been really regulating them. And so we are required to adopt this. And yes, it's late, but we're still required to. So that's why we're doing it now. But we've received a lot of inquiries about these rules, about whether there's going to be a rule, whether there's a way we can do this. And that's when we discovered that we had never passed the rule as required. Thomas, do you have anything to add to that?
Excuse me. Good morning. I'm Thomas Graham. Shannon, thanks for doing this. And thanks a lot for calling me out too. I really appreciate that as well.
Sorry.
So really where this comes from, you laid it out, I think, perfectly. We have Chapter 1605, which requires the agency to have a rule stating how wineries can interact. When I think about 1605, I think about contract winemaking, alternating proprietorships, those types of scenarios. And that's what 1605 says, is that the wineries can work together, and then they file their agreements with the commission. And then we need to have a rule in place that says how those what they need to include, what they can be, that kind of thing. The language is real clear in statute for breweries and manufacturers of what they can do with regard to alternating and contract brewing, things like that. I think 1605 is a similar statute in the winery section. It just doesn't go into those details. And that's what gives and requires the agency to pass this rule, is that wants us to work with the industry to make sure that, we're detailing what those types of agreements between two Texas wineries can be. So that's what we tried to do with this rule that we're getting around to finally doing, is we wanted to lay out the shared premises, alternating proprietorships, and contract winemaking, and that how those things can work. So as far as going through each specific division, go ahead.
Yeah, I can just tell you how basically the structure of the rule is that there are certain things that we want every person or winery permit holder doing, and those are the first half of the rule. And then down in G, you're going to need to file your contract or other agreement with us, and there's a list of what that agreement needs to have in it. So we're not going to tell you how to comply with 1 through 6. We just need you to file something with us that says what you're doing with regard to that. And up here, we do have a fee, $1,000 fee, which is, I've added some language since maybe some of y'all saw this the first time, to clarify that that's per permitted premise. So if you've got, 4 wineries sharing a facility, that's going to be about $10 a month for the 2-year per person if you divide it up evenly. So prior to commencing, you'll need to get the authorization by filing your operating agreement, a premises diagram, and your fee. All parties have to have a G winery permit. We had proposed that for purposes of audit and enforcement that, if an agent goes into a shared facility and they see a product and they need to identify who is responsible for that product, that we would go by the COLA holder. We may make some adjustments to that based on some very narrow circumstances where for example, a brand owner might not be the COLA holder. But the purpose of that is just that we need our agents to know who is responsible for a product without having them have to make legal determinations, parsing private contracts between third parties. So we don't want our folks having to read contracts and figure out who's responsible for what. So we're trying to come up with sort of an easy shorthand way that is fair for us to identify who's responsible for each product in a shared facility. So that's what that's all about. Do you have any specific questions about any of those sections? Amy?
Plenty, which I apologize in advance. So Thomas, with all due respect, you and I have been going to the TWIGA conferences for many years. This has been no secret. This is what's been going on in the industry. Everybody's known it. This isn't new. The statute has a provision that was put in long before contract brewing that allowed operating agreements between wineries. The application asks if there are any other agreements that the applicant must disclose. I'm just curious about if the provisions have been there. And, you know, this is like newfound to perhaps this administration. What activities have you all participated in with researching what's going on to have drafted this rule? And furthermore, why a fee when clearly there are other types of facilities that are shared in the statute, and those people are not paying this $1,000 fee? I appreciate your short summary, but obviously there's a lot more to this than you're discussing with us. And I'd really like to just understand how it is that some of this came about when the statute's been in place for quite some time. And how did the fee get arrived at? Thank you.
So
Sure.
the fee, I can answer the question about the fee. And I'm not sure what types of facilities you're referring to that aren't paying a fee but that are similar, but we decided upon proposing the $1,000 fee because that's the same as I believe a regional forwarding center. Is that accurate, Thomas? I think that's right.
That's licensing.
Yeah,
Yeah.
that's what it was. And it's, you know, similar sort of business function. So that seemed fair to us.
How's that fee going to be coded? You have to code the monies that you accept to LBB. And if this isn't a certificate, a license fee, or is it going to be coded as a license fee? How is this fee going to be reported to the legislature? I'm curious.
I don't know. I can't answer that. Is there anyone else who's on the call from the agency who can answer that question? If not, that's something that I can follow up on.
Which also, Shannon, when we do ask these questions, do you follow up with all of us as a group or just to the individual that asked the question?
Just to the individual that asked the question.
If I may make a request for all 71 of us on the call, if you wouldn't mind following up with all of us concerning the questions we ask, I think it would be very, very helpful and would avoid some of the confusion in the industry when one person gets an answer and others don't. Just another recommendation on my part, please.
So Amy, while she's taking notes on that, and we'll figure out exactly how they laid out the fee and how licensing is going to code it. And we'll figure out, you know, Shannon will get it back to everybody. As far as addressing your other questions outside of the fee of how the rule came about and things along that nature, we've had questions and complaints filed, and we've done some other investigations and looked out there, and we looked at all of, as we're going through the sunset process and we're going through our rules, things that are missing. And again, this statute 1605 requires that we have a rule, and it's never been done. So what we did is we looked at, like you talked about, you mentioned TWIGA and things like that in the past. We tried to think through all the different scenarios that we've seen out there and put them in this rule as something that's authorized. So if you go through it and we're missing one, let me know. But I feel like we, you know, based on just this initial one, the initial draft here, I think we covered a bunch of them, but I'm sure there's tons out there, and that's where we need input from industry on what we're missing. But if you look at this, on what we try to cover so far, we talk about authorized activities under 1601. We talk about 1609, which is the shipping piece, and then 4504, and that's in D, which is storage, right? So this, and then we also talk about, she's highlighted some stuff for me, sharing facilities for doing that. So whether or not I have a crush machine, or whether or not I'm going to have an AP agreement or contracting, all of those things I think are things that you've mentioned historically have been happening in the industry. We're putting them in rule, saying that they can happen in this rule, and then detailing out just what the agency would like to see in the contract, which is who's going to pay the taxes, and show us, how you're separating out the facility. Those are standard practices now, I think, that we would follow if we were asked to do these things. Now, if we're excluding anything, or we left anything out, and I'm sure we have, let us know. But that was what we tried to do, is lay out everything we've seen so far that wineries in the state of Texas are doing, and then put them in here as things that can be done. We just asked that they go into the contract and that we see them.
Right. And I would just add, I mean, that's really the purpose of this stakeholder process. Is we tried to cover the activities that people are doing, but I know that there are a lot of different business models with, slight tweaks, and we might not be aware of all of them. And so that's why we're hoping for input from all of you to make sure that we aren't excluding something that we should include, or vice versa. So we're definitely expecting to get some input on this one.
One last thing. So my first is, do you envision that you would review these operating agreements? And with 3 saying that the $1,000 per permitted premise is subject to the operating agreement, can you kind of explain how those two things connect, or do they?
When you say subject to,
I'm looking at B3, and then B1. So an operating agreement that meets the requirements. So I'm assuming you would request that agreement from each participant. Right. And then 3, a fee of $1,000 per permitted premise subject to the operating agreement. What does that mean? Subject.
By that I mean there's $1,000 fee per premise, and so I guess there could theoretically be a very broad-ranging agreement if there's a group that owns multiple premises that they're doing this type of business model on. I'm not aware of any right now, but if they came into us and had 2 different warehouses or whatever they have, then we would want $1,000 per premise that's a subject of that agreement. So it's just trying to clarify that it's per premise, not per person.
Amy, one of the things that you mentioned earlier, and I said we're trying to cover everything. One of the comments we've received already was asking about like custom crush facilities, and they have a bunch of facilities. So I think we need to, we still got to work through that in that comment and figure out how we update it. But that could be like a scenario where you've got multiple facilities and multiple operators, I think, with some of those custom crush places that exist.
I appreciate that very much. I would recommend that there be some clarity brought to that. It just seems confusing to me what is the person being charged for. So perhaps clarity in those sections would be helpful.
Okay, I just made a change, so it's be per permitted premises that is a party to the operating. Well, no, that doesn't make sense either. Okay, well, I'll work on it. I can see how that can be confusing.
Thank you.
Marcus Schwartz, Bracken Schwartz, have one substantive question related to C. that each party to the agreement must operate a winery and hold a winery permit. I think there's very similar language in contract brewing for beer, and just want to confirm that that would mean that these parties need a winery permit already somewhere else, presumably, in order to then do this shared facility at a different location, correct?
Correct. Yeah. We're thinking 2 wineries that already have permits working together, which has been how we've seen current practice. But not
Understood.
necessarily getting multiple winery permits or anything.
Gotcha. Yeah, and I think that's an important consideration. I know a lot of people are potentially worried about a bunch of out-of-state people all of a sudden trying to use this to ship wine direct to people. So I think that's an important consideration.
Yeah, that's something we're aware of and trying to make sure it's clearly not allowed under this particular rule.
Yeah, Marcus, we looking at 1605 to us, I mean, it talks about it being 2 wineries, and with it being in chapter 16 and not in the non-resident sellers chapter, we definitely had that in mind. And so we'll look at this. We tried to touch on it a little bit with the cola piece, saying that at least one of the parties needs to hold the cola. And I think that's where maybe some of the confusion came in with the custom crush. So we're working on getting that language right to make sure that we're doing this the right way. But it with 1605 and the way we're trying to write this rule is we're really looking at just 2 Texas wineries or more working together to produce products, because one of them may not have all the facility stuff that they need to do it. If you look at this and you, especially with our updates and anything else, please send Shayna any suggestions you got on language, because we do want to be clear that we're talking about G permittees and trying to stay within the confines of chapter 16 in the code, which is talking about just the Texas wineries.
Right.
Thank you, Marcus. I appreciate it.
Good morning, Shayna. My name's Ricky Knox, President of the Wine and Spirits Wholesalers of Texas. I want to thank you and Thomas for laying out this rule in more detail this morning. First, the Wine and Spirits Wholesaler of Texas, we totally support the Texas wine industry because we sell a lot of Texas wine to Texas retailers every year. But we have serious reservations and concerns about this rule, and we think justified concerns because of legislation that was passed last session to create Texas wine fulfillment centers. And I understand what Thomas and the previous speaker were talking about, the concern about direct shipping. And those Texas wine fulfillment centers that would have been created by the legislation would have helped Texas wineries. But the reason the bill died was because it allowed out-of-state wineries to be able to bring wine into these Texas wine fulfillment centers and conveniently and cheaply sell to Texas consumers, which we think would have been devastating to our Texas wine industry, and we still do. As Lance Lively previously said, we would like to work with TABC and the legislature and really reviewing this. I'm probably the only one on this call old enough to remember in 1985 when this legislation was passed by the late Senator Frank Madla. And we would like to go back and review what the legislative intent was on 1605. But our total goal is we want to help the Texas wine industry and make sure the Texas wine industry remains strong in the state of Texas. We look forward to working with you. Thank you.
Thank you, Mr. Knox, and feel free to reach out to me. I know most of you already know how to do that, but I'm going to go ahead and give you my email address is, of course, shana.horton@tabc.texas.gov. And I really hope that you will all reach out. I do want to mention, just while we're talking about the process here, that next month our commission meeting is going to be a week earlier than it usually is because of Thanksgiving. And what that means is that our timeline is compressed by a week to work on the changes that you would like to see to this rule. So with that in mind, we really would like to keep it on track to go before the commission as a proposal next month. So with that in mind, please reach out as soon as possible. Next week, definitely, if you have some thoughts and some proposed language would be preferred. Or even later today, it's just fine. So we're kind of on if we're going to stay on track, we're going to have to do this work right away. So with that said, is there anyone else who would like to make comments?
Shana,
Yes.
this is Sherry Huddleston, Hant Scarborough. I represent Southern Glaciers. And I just want to echo what Ricky Knox has said. We understand that y'all are required by statute to set forth a rule. We do have concerns, just as Ricky has stated, and we would personally like to be involved with any discussions that y'all have in meetings, so that we can, set forth a rule that is exactly what y'all are thinking that you're trying to accomplish, or not thinking trying to accomplish, but are trying to accomplish. And so with that, we just appreciate being involved.
Okay. We'll make sure and get a meeting set up so we can hear, and perhaps just Mr. Knox, Ms. Huddleston, anybody else who wants to be in on that call, let me know. We'll set something up rather quickly.
Shannon, Amy Harrison again. Thomas mentioned some investigations that had occurred as a result of complaints that were received on these activities. I'm just curious if any of those investigations resulted in violations.
I don't know the answer to that question. Does anyone else on the call know the answer to that question?
Shana, or Amy, you keep calling her Shannon. It's Shana.
So, okay.
I'm going to take that opportunity to tell you.
Thank you, Thomas, and I have my deepest apologies. And as usual, you are always correcting me, Thomas. So good to have you.
Amy, I don't know if anything resulted. I think it was one of those scenarios where we went and looked and we had some complaints, and then we said, okay, well, here's what's going on in the industry. And we'd have to drag audit into this to tell you where that was. But I think that's what really prompted us to move forward to get a rule, is that we realized we didn't have a rule clarifying what was and what wasn't okay. And this rule is, filling that gap, because we did get complaints, we did go out, we did see different practices taking place. And so that's why we wrote the rule the way we did, to say, well, it looks like these kinds of things are the types of agreements that are taking place out in the industry. Let's put them in the rule and move it forward, so that it's clear that you can do these things or not do these things via an administrative rule, which is required by statute.
Makes perfect sense. Thank you, sir.
Do we have any other folks who wish to speak?
Yes, ma'am. This is Chris Brundrett. Can you hear me?
Yes.
Awesome. I wanted to speak to, this is Chris Brundrett with William Chris Vineyards in Texas. And yes, we can wine as well as Lashrock Cellars. I wanted to speak to the proposed legislation last session that didn't relate to G permit holders or Texas wineries whatsoever. That bill put forth by Senator Buckingham was solely for out-of-state shipper permits and had absolutely nothing to do with Texas wineries. So I just want to clarify for everybody out there. We followed that bill closely, and again, it had zero to do with Texas wineries. It was only to do with out-of-state shipper permits, and totally separate from the Texas wine industry.
Thank you for that clarification.
Yeah, absolutely.
Is there anyone else? I am looking to see if we've got any hands raised. Okay, I see no hands raised. Again, as we've been saying all along, you know, this is in the draft stage and we do want your input. The best kind of input is draft language that you would like to see. So that's the most helpful thing you can do. And the sooner we get that in the house, the better. And again, we're on that accelerated schedule. That also applies to the next item on the list. If y'all are ready to move on, which is amendments to 45.103, let me go ahead and share that just a moment. Okay, is that showing 45.103 or is it still on 35.8? Oh, here we go. There we go. Okay. So here's our draft rule 45.103. As I mentioned before, this is something we're starting to go through all of our rules on the 4-year cycle, and chapters 41 and 45 are the ones we're starting with. The amendments that we are suggesting for 45.103, the primary amendment is down here in subsection D. And the idea behind this is, you know, when you go to a charity event and your firm buys a table for $2,000, we don't want you to have to go back to the bar and pay cash every time. So we feel like for very limited types of ticketed events like that, charitable events, that it would be appropriate to allow more than one beverage or more than 2 beverages to be sold under a single ticket, which would otherwise not technically be allowed under subsection C8 of this rule, which requires that the person not sell more than 2 drinks to a single consumer at one time. So we're trying to clarify that C8 should not be used to prevent the sale of a ticket to a charitable event. And then we've also included a public entertainment facility, and I'll explain why on that later. And so that you can get an open bar kind of situation at a limited number of types of events. The public entertainment facility, that's also a limited number of things like sports arenas. It's strictly defined under the Alcoholic Beverage Code, and this came up because there's been proposed to us that there might be a season ticket or a season pass that with the season pass to that public entertainment facility, it would include alcohol. And so those are the 2 specific types of situations that we're trying to make it okay to sell a pass that includes more than 2 beverages. And then what we've done up here at the top is just to remind and emphasize that, no matter what, even if you've got a season pass or a ticket that includes unlimited alcohol, your server still has the responsibility to refrain from serving to an intoxicated or underage person. So that's the backstop that keeps people from going too far at a charity event or a public entertainment facility. We still have the server there to make sure that that over drinking isn't happening. So those are the changes that we're recommending, and I will open the floor. I think I might have a comment from. Okay. Does anyone have some comments and questions on this one? Remember to state your name and who you represent, and let's go for it.
Hi, Shana. Can you hear me?
Yes.
Hi, this is Kent Killo. My wife and I own Vista Brewing in Driftwood, Texas. Just one thought on this, in question or at least suggestion, is why it would be only limited to temporary spaces or temporary permitted premises, or if there's a way for us to bifurcate for other venues that already have permits, but that would otherwise achieve the spirit of the change in this regulation. And for example, selfishly, our venue, we have a 21-acre property in Driftwood, of which we host charity events, where this would be exceptionally beneficial for how we raise money for those charities. And so in the spirit of why we would make this change, I would want us to be able to pass on that same benefit. And similarly, I would assume Mr. Brundrett, who's also on the call, has a similarly large property that would that hosts similar types of events that would like to be included in this change if we're able to be.
Yeah, thank you for that comment. Yeah, I understand that there might be some situations where that would comport with the spirit of what we're trying to do. The issue is that we have to make sure that there is not a loophole to be exploited. That a bar on 6th Street can't call something a charitable event and sell a ticket to it and basically have an open bar party on 6th Street. So that's why we were limiting it to temporary events at temporary locations. We don't want, bars to say, well, if you pay us $100, you can come in and drink all you want. That's kind of a recipe for disaster. But I realize that that's not what would happen at your property, but there's just, that's the reason that we limited it the way we did, just for explanation.
And that makes absolute sense. What I'm suggesting is that we would be able to still make a distinction between the types of venues, or be able to clarify between types of venues that could utilize this for the spirit of the change without falling into that slippery slope trap that you're trying to avoid.
That's a good idea. We would definitely welcome your assistance in coming up with some language that would let you guys in and make sure that no one else can take advantage in a way that we're trying to prevent. So if you want to give me a call or shoot me an email, we'll definitely work with you to see if we can find a way to thread that needle.
Shana, could a note
Absolutely.
Sorry, Kent. This is Charles Valenart from the Texas Craft Brewers Guild. Shana, could another alternative be for an operation like Kent's to a very large property, that he could take a section of his property, modify his his premises map to reduce it, and then designate that non-premised area as a temporary location for such an event, and then fall within the update of this rule?
Charles, this is Thomas. That's something I think to consider. Licensing, of course, has to look at that and determine whether or not it's legal. We don't generally go in and do that when it comes to retailer premises. We definitely do it in scenarios where they're like a winery or somebody, or a brewery that's got a lot of property, and they don't want the commission on the unlicensed area. So I think that's something that we may have done in the past, and it may be something to consider in the future. But I would also say, as we're looking at the language in this rule, if y'all can work together on, like Shana mentioned, something helping us thread that needle, versus, running into that scenario where we would have to go to Kent and say, Kent, you got to undiagram this, and you got to split your property here. we're welcome, we're hoping for industry suggestions and language so that we can do this in a way that we can accommodate that scenario, if possible. But again, the main thing that Shayna had touched on, we still got to stick with the spirit, which is we want to make this easier and make it legal for these kind of things, for charity events in the spirit of the law, and we got to worry about public safety too, right? So how we thread that needle, we need y'all's help on. For big facilities like Kent's, he said he had 21 acres. And maybe he's got a big charity event out there, and maybe undiagramming is a way to go. I can't speak for licensing, and that's what I'm saying there in that scenario, or how we would necessarily interpret it at the time. But if there's a way to make that work in this language that ensures public safety, and then sticks with the spirit of what we're looking for, we ask that you guys look at that and come back to us and let us know.
Thanks, Thomas. Yeah, I'd much rather, if there's a thread the needle opportunity, much rather go that route. Was just looking for some kind of alternative that could work as the code exists today or rules exist today, but we'll definitely take the opportunity to come up with additional language, and we'll work with Kent on that so it represents a broader audience.
And Charles, I've talked to Kent a little bit too, and I just can't say on the phone that's a good way to go. I mean, that's the way we would do it. I think that just is real specific to each location and each type of event. That's why I can't commit to anything like that, or commit on behalf of a different division either on how they would handle it. So hence my answer.
Thomas, this is Amy. Hotel premises, did they make the list just because hotels are so special, or how did they make the list, please?
Well, since hotels have the authority to say that you can move around the premises with your product, and that when we permit them, as you well know better than me probably on how we permit these things, but we generally, when we permit a hotel, try to just permit the bar area, right, or the restaurant area and where they keep the alcohol, versus the ballrooms. And so, because that way the hotel could rent out the ballroom to somebody that may want to bring in their own alcohol, or maybe they want to hire a specific caterer to come in there. And because some of these hotels end up being tied to like big event spaces, or they have those big ballrooms and those big charity events, and because they've got that language in the code that we can treat them a little bit differently, that's why we plugged them in there, because we know a lot of those charity events do happen in those unlicensed hotel rooms, and then they'll either bring in the hotel to be a third-party caterer, or they're bringing in a third-party caterer. So that's kind of why we're thinking it could fit into the same scenario, versus, and why we had some statutory language to make a distinction between them and like a bar or nightclub.
Makes perfect sense. Thank you.
Other comments or questions? 45-103.
Well, please, once y'all have a chance to also, like Shane has been saying, look at this language, send us your thoughts and feedback on it. It's a different direction than we've gone, but we've constantly run into the issue over the years of big events and festivals and things like that, and telling people you can only have 2 drinks within the ticket price, and then you can split those up into 20 different little samples. So we're trying to do this here and ensure that we're also keeping public safety in mind. But we want to make sure we're covering this appropriately and getting those events in here in a way to make it work that's safe.
Hey, Shayna, I have one comment.
Go ahead.
Just kind of in response to the question about the undiagramming and all that, I don't really think any of that would be necessary, because under D1, it does allow people and permit holders to kind of structure events and have a certain section of the licensed premises be utilized for that event, and that be segregated from how we're going to look at the rest of that property where the public's going to be visiting, versus something that's private on a small portion of the winery or another retailer's premises or something.
Okay. Thank you, Matthew.
Thanks, Matthew.
Okay. If there are no other comments on this one, does anyone want to go back to either of the other items while we're here? I definitely want to get everything out on the table so that we can get these things in great shape so that they're ready for the commission a week early next month. So if you have comments that you're not wanting to make here in the public space, definitely give me a call or shoot me an email. And let's get to work on these, and let's get them the way we want them to be proposed. Does anyone else have any comments? Speak up, speak now, or don't forever hold your peace, but speak now.
Many thanks to you and Thomas this morning, and my apologies for your name not being right.
Oh, that's okay.
Amy, I just had to give you a hard time about it. Come on now. I wouldn't.
That's okay, Thomas. It's a good Friday. Love you.
It's a beautiful day, and I hope you all get to get out. And if you're in Central Texas, it's gorgeous outside, and enjoy this weather this either today or the rest of the weekend. So if there's no other comments or questions, we will go ahead and close this meeting. And I'm sure I will see some of you on Monday at our public hearing on the rules proposed at last month's commission meeting. Thank you all so much.
Thank you all.